back with Mr. William Orlow, one of the Detroit area's premier bankruptcy attorneys. In our previous segment, Mr. Orlow explained some of the basics of bankruptcy law. Now, Mr. Orlow is going to discuss some of the details of Chapter 7 bankruptcy. Good afternoon, Mr. Orlow.
Good afternoon.
So, Mr. Orlow, can you give us a short overview of Chapter 7 bankruptcy law and exactly who is it that can benefit from filing Chapter 7 bankruptcy?
Certainly. Well, Chapter 7 is called a liquidation. That's the term that's given to it under the Bankruptcy Code, but most of our clients simply refer to it as a fresh start. And Chapter 7 is an opportunity for debtors who find themselves in financial difficulties and without the ability to pay any of their debt to get some relief in bankruptcy court from that debt. The debt is what we call discharge. There's no one that goes out and magically pays it. The debts are simply forgiven legally. And it benefits many, many people. Often a client will find themselves out of work or besieged with huge medical bills or some other personal circumstances that just prevents them from being able to pay the debt. And Chapter 7 is that social safety net that will allow them to emerge debt-free and get a fresh start, to turn their life around. And I've seen it happen many times.
There's a lot of talk about the new bankruptcy laws. Have these new laws made it more difficult for people to file Chapter 7 bankruptcy?
In certain ways. In 2005, Congress, because bankruptcy law is federal law, Congress passed bankruptcy reform legislation. The legislation was broad and sweeping. And in essence, what it did is it created a financial analysis required of all debtors to compare the debtor's income with what's called median income based on household size and state of residency. And for those debtors whose income is above median, a further analysis is available to determine whether they're eligible. Now, Congress had envisioned a broad sweeping reform that would have prevented many people from filing Chapter 7, but in reality, statistically, only 3% of all debtors in bankruptcy are now unable to file bankruptcy that might have been able to do it before the reform legislation was passed. There were good things in the law and there were bad things in the law. It's the typical law that Congress passes. I'm sure the intent was noble, but it has changed the way that we analyze a case, and there is more work involved. I would emphasize that you need a professional to be fully aware of all of the intricacies of that reform legislation. But in general, it can be more difficult, but for most of people it is not.
I've heard that a person has to take an approved credit counseling course before they can file bankruptcy. What does that mean?
That's right. That was one of the other elements of the reform legislation we mentioned a moment ago. And all debtors who are seeking to file bankruptcy must complete a financial credit counseling course. Our clients typically take the courses online. There are a number of companies that offer the course. The charge is nominal, and they must complete the course before they're eligible to file. Now, the only exceptions would be that if counseling wasn't available in their specific area, or if there was some exigent circumstance, an emergency, if you will, that required an immediate filing. And then, in that case, they would have to complete the course within 10 days of the filing.
Okay. Many people's biggest concern is keeping their house and their car. What happens to a person's home and cars in Chapter 7 bankruptcy?
Well, our clients don't lose their home or their car. However, the debts don't magically go away. If a car is worth much less than what is owed, often our clients can keep the vehicle in Chapter 7 by redeeming the vehicle. Let me give you an example. Suppose our client has a 6-year-old car, they owe $10,000 on the car, but because of its wear and tear and mileage, the car might be worth $4,000. In Chapter 7, our clients can redeem the car by paying back the $4,000 and discharge the remaining balance, the other $6,000. So they'll keep their cars. Now, if they want to keep their home, it's pretty simple. They simply continue to make the mortgage payment as they have agreed to. If they're unable to make that mortgage payment, then they're going to walk away from the house. And many of our clients these days have decided to walk away. However, if they are able to make the mortgage payment, the house is completely unaffected. If we have a case where there's a lot of equity in the home, then we may need to look at a different chapter of the Bankruptcy Code called Chapter 13, and if they file Chapter 13, they can still keep the home.
So what else is a person allowed to keep under Chapter 7, and what can't a person keep?
Well, our clients can keep most all of their assets, so it's very, very rare that our clients lose anything in bankruptcy court. The law provides for certain exemptions, that is, certain amounts of assets that are protected legally under the bankruptcy code, so that when they get their fresh start, they're able to start over with some cash in the bank, earned but unpaid wages. They're able to keep, of course, all their retirement plans. They're able to keep their household goods, their personal possessions, their jewelry. Literally, our clients lose nothing. Now, if they have tens of thousands of dollars in investments that are not retirement funds or stocks or bonds or money in the money market, there certainly is a limit. But the limit, or the exemption, if you will, is fairly generous, and so most all of our clients keep everything that they own.
Can you tell us exactly what happens to a person's large debt, such as credit cards and medical bills, under Chapter 7?
Sure. They're simply discharged. That is, as I mentioned a moment ago, they're legally forgiven. There's no one that magically pays them for you. They're gone by operation of law. And the client is able to start over with a fresh start and be debt-free.
For our married viewers, can you explain how filing Chapter 7 will affect a person's spouse, I should say?
Sure. Well, when we have a married debtor, an individual spouse can file on their own, or they can file a joint case, husband and wife. But if one spouse chooses to file, that spouse's debts will be discharged. But the discharge in that one spouse's case does not discharge the liability of the other spouse unless they join in a joint case, a joint Chapter 7.
Okay. Many people's concern is getting credit again after filing for bankruptcy. If a person uses a credit counselor rather than filing bankruptcy, will they end up with a better credit rating?
Well, I think that's the myth, and no, they don't. As a matter of fact, as counterintuitive as it might sound, debtors filing Chapter 7 often end up with a much better, higher credit rating much faster than someone who attempts to pay their bills. And here's the reason. Credit ratings are all based on risk. The debt-to-income ratio is what's factored in arriving at a credit score. Obviously, the rate of payment, the slow or prompt payment, those are factors too. But if you can imagine a scenario where an individual has regular income and they have $100,000 in debt, they have the ability not to pay that debt. They're a very bad risk, and so the credit score is going to reflect that inability to repay their debt. Now imagine a person who's emerged from bankruptcy. They are gainfully employed, they have regular income, they're debt-free, their income-to-debt ratio is 0, and as we mentioned earlier, they can't file again for 8 years, so they are a much better risk for credit. And I often counsel my clients and caution them at the end of a case to be very careful, because it's too easy to find themselves in debt again.
Well, it sounds like Chapter 7 bankruptcy is an excellent way for a person facing debt to get a fresh start. Is there anything important that we've missed here that you would like to say to our viewers who are considering filing bankruptcy?
Yes, perhaps a couple things. The first thing I want to mention again is that the time to consult with a professional is when you have begun to experience financial difficulty. Don't wait until you've exhausted all of your assets. Assets such as retirement funds are exempt. IRAs, for example, are exempt. That is protected up to $1 million. Don't exhaust all of your savings before you consult with a professional. Don't sell your car or your furniture. Don't go to the pawn shop to pawn your jewelry. Consult with a professional first. The other aspect of bankruptcy that's important to know is that there are clients who have problems with income taxes. And contrary to popular belief, it is possible to discharge certain types of income tax in Chapter 7. So that's a good reason to consult with a professional before the IRS begins to levy, before they've liened all your assets, and before they've taken your paycheck. Consult with a professional first. That's always the best advice.
Great. Thank you so much for joining us today, Mr. Orlow.
You're welcome. Thank you for having me.